Okay, we are live. This is The Secret, How to Fight CPS and Win. I'm attorney Vince Davis, and joining me today is my co-host, Mr. Darren Guai. Darren, how are you today?
You know what? It's a beautiful day in Maine, Mr. Davis. How about yourself?
Doing good, doing good. And we have a special guest today, Ms. Jennifer Mason. Ms. Mason, how are you?
I'm doing well. I hope everybody is. Thank you so much for having me on your show.
Where are you calling us from, Ms. Mason?
I'm calling out of Lynchburg, Virginia.
Oh, okay. How far is that from Richmond?
It's about an hour and a half. So we're like southwest of Richmond, hour and a half southwest.
So what's going on with CPS and they're in Lynchburg, Virginia?
Well, I was actually been doing some research. I was looking at statistics, and we're actually out of all localities in the state of Virginia, in regards to how many children go into foster care every month, we're only number 4. And that's behind Virginia Beach at 200. That's behind Richmond City at 199. That is behind Fairfax at 189. This comes from cardinalnews.org, which is a news, out of journalism out of Virginia. But we rank in number 4 of foster children every month. So what happened with me was in the fall of 2021, I was having some issues with my mental health. I was just struggling. And my daughter was 5 at the time. And I took it upon myself to say, hey, I need to get myself together, and proceeded to give my 5-year-old daughter to my 26-year-old daughter. We even went and signed a standby designated guardianship paper, had it signed, did not get it notarized. And I did not get an inpatient bed until March of 2022. So went to rehab voluntarily, no problems with the law, no problems with CPS. I stayed for the entirety of the program. I get home. 2 days later, there's a knock on my door. It's CPS. They had gotten a report of all kinds of stuff. Neglect. My daughter had gone to school hungry. My house was dirty. All kinds of lies. They asked me that day to do a test. I did. They said it was positive for cocaine. I have a picture of it. You can see a faint line. They that day removed my daughter, which, let me just add, she wasn't even in my custody. She had been with my oldest daughter since the fall. The school was willing to attest to that. I had many people that would have attested to the fact that I was not caring for her. At Christmas, she was at my daughter's, and her birthday, her presents went to my daughter's house. There were several ways that could have been proven, but it wasn't. So emergency order was put in that day for no contact. I was ordered a hair follicle. I passed the hair follicle. In my mind, that should have exonerated me right there. The cup test should have been no more. But that wasn't the case. CPS was then involved. So, I had to start with supervised visits at the Y. I did this all through the fall. My daughter's biological father is Salvadorian. So there was a problem with translators, and what was supposed to be a May hearing turned into a November hearing. So basically, I've never failed a drug screen for them. I've passed numerous hair follicles too. I just did one last week. I'm certain to pass that one as well. And yeah, it's like the harder I try, the more pushback these people give me. I have an attorney that's representing me on the protective order, but like I said, in that hearing, and I don't know the correct terminology, but when they decide the preponderance of evidence, I feel like my daughter's school should have been called. I feel like there should have been witness testimony at that point. I feel like it should have been brought up that I passed that hair follicle after the initial cup test is why they removed her from my care. Number one, she wasn't physically in my care. So I don't know. At this point, I'm looking now at the child protective order. So that was due to be adjudicated in May. And I ran into a little bit of trouble, which I was found not guilty of. So now they're putting it back on the docket. Basically, a judge had told me absolutely no alcohol. And I did get a intoxicated in public charge. which I have since I was found not guilty. I fought the charge. I was found not guilty. Because that was in the order, they stopped my unsupervised visits immediately and they put it back on the docket. So it's no longer adjudicated, or whatever that means. So yeah, at this point, I know I talked to a lawyer and they told me the time to fight this would have been in the first 30, 60, 90 days. That wasn't done. So, I mean, if it was up to me, I would have fought it. I've been gathering evidence the entire time. I just never thought that that could be done. How do you go to rehab, come home, have a child removed from your care that wasn't even in your care? You know, as a family unit, when I decided I needed help, I did what I thought I had to do. That was give my daughter, my youngest daughter. I mean, I don't know what the judge thought I could have done differently in that situation. But that's what I did. And so I don't see how they could, all of the allegations in the initial affidavit could have been disproven if my attorney had only done it, put forth an effort. So at this point, the judge, I feel like, is a little biased towards me. They take away the one thing that gives me my drive, that gives me my motivation. I mean, drugs has been my problem. And I have proven every week, I've had clean screens every week from a lab the entire time. I don't see, and then the alcohol thing, I feel like I'm grieving for my children that are alive. And I'm dealing with it the best way that I can. But it just seems like the harder I try, the more pushback I get, or, so I don't know. So that's kind of where I'm at right now. Right now it's being put back on the docket. I don't, like I said, I'm looking at a child protective order, but it's not a final order. So in regards to like the terminology, I'm not sure if, I know the adjudicatory hearing was done, but the dispositional hearing, what it's called, the dispositional hearing. I don't know if that's what they're putting back on the docket or what, but the child is with her father. She's not with foster care. So I am blessed that is, and he lets me see her all the time. That's the thing. This whole time I've been seeing her. She was in gymnastics twice a week. We went to church every Sunday. And as soon as, I had got the charge, which she was not with me that weekend when I got it, again, been proven not guilty. They immediately stopped my visits, unsupervised visits, put me back on supervised visits, and are just making me go through the most just to, and I feel like, again, this shouldn't even be at this point. I feel like my lawyer didn't fight for me, basically. So, yeah.
Well, hold on. Let us ask you some questions. Darren, I'll let you go first, or do you want me to go? I'm not too good at reading lips, Darren.
Sorry. I had a good one too. Now it's over with, so we lost that one. I'll save it for next time.
Okay.
Mr. Davis, if you don't mind, I'll go ahead and go first. If
go ahead.
You're fine with that. All right. Jen, so your daughter's how, 5 years old, you said, right?
She's now 6. She turned 6 in February.
Yeah, mine just turned 6 yesterday too. How long was this going on before you decided to go? Was there any sort of indications with CPS at all before you decided to go to get yourself help?
No, absolutely not.
So no previous.
Not with this child. I've had prior issues with my 9-year-old, but she lives with her father. She's part of the case, but not so much. I've always gotten her on the weekend. So she lives in another county because I didn't have physical custody of her. She's not so much a part of this case.
Okay, I see.
But yes, I have had issues before in the past. Once founded, once unfounded, but nothing like this.
So had you lost you didn't get TPR'd or terminated your parental rights from any other children?
No, never.
They're just unfounded. So you completed the program, right?
Right.
And then you gave was it a order of you handed your daughter over to your oldest daughter, right? You get it.
That was the fall of the year before, 2021, actually.
Okay. So
I didn't go to rehab until March of 2022.
Okay. All right. But when you came home, your daughter still had guardianship over her.
Yes. Yes.
And
yes.
Then what, they got a call, they got a thing from the school or something that said that she was, how did they call?
I don't believe it was from the school. And the reason why I say that is because I contacted the school and the school said they had never reported that she's never come to school hungry. They had absolutely no idea what I was talking about. I believe it was a gentleman that I was seeing prior to going into rehab. The only person that was close enough to know some of the things in the protective order was him. So I believe that they came from him, just out of malice, to be honest.
Oh, it's terrible.
But yeah, the school would have backed me. There was so yeah, they got an allegation, and CPS showed up with an affidavit.
Right. And then they had you do a urine screen, right, for the first day right there on the spot?
They told me they asked to come into my house. Again, my daughter hadn't been living there. I hadn't been there in a month. I had,
Right.
So I let them in the home. The home was a little cluttered. The home was messy. I found my paperwork for the guardianship, showed it to her. She wanted me to come to the office to do the test. So I went to the office to do the test, and that's where they said I was positive for cocaine. And I have a picture of the cup, and you can see the line.
Right. So that was just like a standard old cup test that they had you
Yes.
go in there, and has the little lines on it. All right.
Yes.
And then when did they ask you for the hair follicle test? Immediately following?
April of 2022. So approximately a month and a half later. Because my timeline, let's see.
But so I guess what I'm getting at with this question is that hair follicle came back and it said it was completely negative?
Completely negative. I had just left. Yeah, completely negative for everything.
Right. So,
meth, coke, especially the cocaine. Yes,
well, that's
everything.
what I'm getting at here. So now they have a hair follicle test that shows that that urine screen was off.
Yes, that's
but
right.
Then, so when is it that they decided now just to go ahead and snatch your daughter up?
That day, the day that I went into the office, my oldest daughter, my 26-year-old who had been caring for her, also went for me. My daughter, even though weed was legal, she's never dealt with the police. She tried to, she was only dirty for marijuana, but she tried to alter the test. They caught her altering the test, so that immediately excluded her. Made her look bad, even though she is a teacher at a local public school.
Oh, it makes her look worse, right?
Yeah, really bad. I know, but her intentions were good. She didn't know that marijuana
no, absolutely.
was okay,
Right.
So they put her with her father, who speaks no English and who's actually facing deportation charges.
So okay.
Yeah.
So what were they saying? What did they say in your preliminary protection order that they said the imminent danger was?
What do you mean? The preliminary one?
Yeah, well, I don't know what they call it.
Yeah, I've got it right here.
When they took your daughter when they took her from you, what did they say your imminent danger
just that my drug and alcohol use, they said was an issue. My drug and alcohol use. Then that, because they thought that I had given them a dirty screen for cocaine, and they were standing on that. It wasn't until mid-April when I did the hair follicle that exonerated me from that.
Right,
and but so it was all about my drug and alcohol abuse, my history.
Right, but you had come home from completing your stuff.
From Turning Point in Georgia. Yes.
Right. And then you come home from that. Then they do all these things. I see it looks like a frag, the urine screen, but all the urine screen shows is that somehow there's some sort of something got into your urine. Who knows? It could have been anything. And then
I can see the line on the cup. There was nothing in there.
And they wait this whole time, and then you do the hair follicle test and they take your kid.
I'm sorry?
So then you do the hair follicle test and then they take your child.
No, they took my child that very day that I got the next day when I returned from rehab, the day they gave me the drug test in the office, they removed my daughter from my daughter and placed her with her father.
So your first incident, your first exposure to them, they took your child.
Yeah. I'm sorry. Yeah, they did. They called it an emergency protective order. They did like a no contact emergency protective order against me.
Holy smokes. So that was
I know. I feel like my rights have been
boom, and it's just that's that. Wow. Okay. I was thinking that it was down the road with that hair fall. I didn't
No.
I
was asking for family partnership meetings. I thought that removal was supposed to be the absolute last thing that they did. I thought
it is supposed to be.
Sit down and talk. None of that was ever done. Right. She immediately went with her father.
Right. And then now they said that you were getting unsupervised visits, and then they take those back because you've tested positive again, or no, none of that?
No, I got an intoxicated in public charge.
Oh, okay, so you got charged.
But I fought that and was found not guilty.
Okay.
So they're testing my hair now for alcohol.
Okay.
But again, they've said that so here's the thing. You know how I was told you I was given weekly screens and they were clean?
Right.
They were showing dirty for alcohol every week.
Okay.
So that's why the judge was like, okay, Ms. Mason, you've made great strides with your drug problem. So proud of you. But I see that you have alcohol in your system. I'm going to put in the protective order, no alcohol. And she put it no, and she underlined it, no alcohol. So as soon as, like I said, the case was going to fall off of the docket or adjudicator, whatever.
Right.
And when they learned of this, don't know how they learned of this, but when they learned of this, they called me, said they were going to modify the safety plan back to supervised visits, and that it was going back on the docket, and it might be the fall of this year before we even go back to court.
Why did you adhere to their questions to do the urine screen when they first had you come to the office? Did you have an attorney or anything at that point?
No, that was a huge mistake because I had just gotten home from rehab.
Right.
And I knew that I knew I was clean. I knew in my very core I was clean. I knew where I had been for the past 30 days.
Right.
I knew all these things. I knew too, like I said, I get weekly screens that I could go to the lab and have that test done. And that's exactly what I did when I left social services. I went to my behavioral health doctor, where I'm in part of an OBOT clinic. So I do medication assisted treatment.
Yeah.
So they have to test me every week. So I immediately went there and I had the test from that too, saying that I was clean from cocaine.
Right. And they won't accept that, right? The DHS won't, or whatever, they won't accept that test, right? They're not allowing you to use that.
I mean, the judge looked at them, those were the tests that she was looking at. Like CPS has done very few tests on me other than hair follicles,
Right.
Instead of showing up and giving me random urine screens, they just kind of let me be. And then, hey, every 3 months, they're having me go get a hair follicle, which I've passed 2 now.
Right.
But yes, the judge was looking at those tests. She was accepting those tests from the lab because that's where she was seeing the ethanol, the alcohol at.
All right. So the preponderance amount of evidence, that was at your shelter care hearing or the after, whatever they call that, right? The 72-hour hearing. Was that the one that you had?
Again, I was getting a little confused because they kept because it was 2 different kids and they had to do an order for both.
Mm-hmm.
It got kind of confusing, but my understanding was at the adjudicatory hearing where she said, okay, I found that there's been enough evidence here to prove neglect. It wasn't until after that I realized that was the hearing we should have fought at. That's when we should have had the school there. My doctor was willing to come and testify or give a disposition on my behalf. My attorney never reached out to him. There's so many ways I could have proven that everything in the initial affidavit was a lie.
But you were never notified?
When I talk about it, my attorney's like, we can't go back. But we wouldn't
But
be
were
here.
you notified about that prior to? Or did your attorney just say come to court and that was it? I mean, did he give you an opportunity?
No, I was receiving notifications.
Okay.
We would go to court though, and like the translator wouldn't show up and they'd have to push it out for another 30 days. And what was, supposed to have been over, I think, May. It was pushed to September, then it was pushed to November, and then November, that's when I got the actual child protective order of abuse and neglect, and it was put to be adjudicated in May of 2023.
So what are your services now? What are they saying that you have to do to relieve your jeopardy?
Yeah, so that's the thing. When all this happened, before I left Georgia, I already had intensive outpatient set up. I already had my OBOT doctor set up. I already had every service that I've had, I had in place before I left Georgia. So they haven't done anything for me. They're not basically in all the orders. They're just saying comply with all DSS requests, releases, refrain from all alcohol, drug abuse, and at LDSS discretion. Both orders say basically at LDSS discretion. So they can pretty much tell me what to do, when to do it. But as far as services, I've completed IOP. I've done continuing care. I still go to see my doctor weekly. I've done a lot, but it's nothing that they've told me. And when we finally got that family partnership meeting the day before our court date in September.
Of course.
The day before our court date is when I had the meeting that I understand is supposed to be the one in the very beginning where we sit down and we talk about, what's best for the child.
Right.
But you acted very surprised when I told you it was that day that they removed her from my daughter's care. Is that
Well, I mean, with no prior history or nothing getting ready to happen, that seems
drastic?
very intrusive. Or I mean, what say you, Mr. Davis, on that? Like just an immediate, here we go, we're taking your kid right now.
Well, I see a lot of problems with this case. And if I may be honest, not only on the social worker's part, but on Jennifer, your part.
I know.
So let me, I took some notes here. Let me go over some things, okay? When you were talking to Darren, you used the phrase a couple of times, I think. It was your understanding. Okay. You know, and I talked about this the other day. Darren, I think you were on the show. Miss G was on the show.
Yes, sir.
Your understanding, although important to you, is the wrong measuring stick. And
Obviously.
I think that, unfortunately, you fall into the category where a lot of people do, and they judge their situation by their understanding. I have a video on YouTube called What is Justice? I'm standing in front of a whiteboard. And I was explaining something to a client who actually videotaped me and gave me the videotape. Justice isn't what you think it is, but in your heart of hearts, you believe you know what justice is. The other day we were talking, I think this was yesterday. Um, you know, what was the issue, Darren, yesterday we were talking about?
Well, it was about how law isn't 2 plus
Oh,
2
yeah.
isn't 4.
All
Right.
right. So, Jennifer, let me ask you something. What's 2 plus 2?
4. No.
No. It's what
No.
the law says it is, and the law is very flexible. I don't know if you noticed it. They can move around and do what they think is best for the child, and by they I mean the social worker and the judge, right?
Sure.
So
Sure.
you have an understanding of what the law is. They're not doing that, and automatically they're wrong. Okay, and that's not the law at all. Okay, but this begins even before that. So let me go back to the beginning of your story. Let me ask you something. Was the attorney you had private or court appointed?
Court appointed.
Okay. So I don't want to be harsh, but you got exactly what you paid for,
Right.
right? Because there's a lot
Right.
of things there's a lot of things that could be done. First of all, a drug screen isn't, you don't have to take notes. This is going to be on the internet forever. Okay.
Okay.
You can watch it
Okay.
24/7 forever.
Okay.
Just
All right.
listen. Just listen. Listening is important, by the way. According to an expert attorney and forensic scientist and drug testing expert we had on a show maybe a week or two ago, his name was Okori Okorocha. Okay. He's a very well-known expert, and he testifies in a lot of criminal cases regarding drug testing and the such. Drug screens aren't admissible in evidence. So that P test you did, that's not admissible. And here's the problem. And by the way, I just became educated on this, so don't, blame your attorney too much. A drug screen does not equal drug test. Only drug tests are admissible in court. Now, here's the problem. If you or your attorney doesn't object to the drug screen on the proper
Mm.
on the proper grounds, it comes into evidence and is used against you. I told a story that happened to me in a Northern California case. And this is what happened. I'm sitting in court, and the judge orders my client to go outside into the left into this office next to the courtroom. It's just an office to do a test for alcohol. And I told the judge, well, I object. That's crazy. This is not a testing facility, right? An office. And what one of the attorneys says, the attorney for the hold on a second, okay? Hold on a second. Okay, what the attorney says is, oh, that's what we do all the time. Okay. Now, I didn't know the difference between drug test and drug screen, but I knew that peeing in a cup in an office next door where there's literally a desk, a fax machine, and a printer and a couple chairs, that's not admissible in the court in California. Okay, so I objected. The test comes back positive, right? And I told the judge, I said, Judge, if you're going to use this to take my client's kids, I'm taking this up on appeal. You're going to use a test done in an office in the courthouse? No testing facilities, just a cup, dipping a stick like you bought at Thrifty's or Save-Ons or CVS, right? So he ordered her to go after court to the local drug testing facility to take the test. Again, to take a test. She takes the test. The next day we get the results negative. Okay. Now this is a real drug test. Machines, meters, all that kind of stuff. And as much as I want to say it, they really didn't want to accept it. Right? They wanted to rely on the office test. But they did, and they didn't take away the kids. Only because I let them know that I would take this up on appeal. And if I take it up on appeal, and if I win, guess what? They can never do that again. And they're not about to put that lady out of a job, and they're not about to stop the convenience of using that screening urine thing because it's cheap. It's fast. Okay? It doesn't cost anything. All right? But I'm here to tell you that that kind of test is not admissible in court if you object.
Okay.
So you and your attorney didn't object. Now, you didn't know to object, and your attorney probably didn't know to object because he or she's probably been, they've been doing this since the beginning of time. All right? So I don't know if we have to fault him or not fault him, but that's the bottom line. So that's the first problem, your selection of attorneys. Now I'm going to ask you if your child, this case is probably the most important lawsuit you'll ever be involved in your life. Right?
Absolutely. Absolutely.
Okay. And forget about finances for a minute because probably like everyone else, it's difficult to hire a private attorney. Do you think you should be using a court-appointed attorney?
Absolutely not. Absolutely not.
And you know what? At least in California, the rule is, and I'm going to use some of my own descriptions and adjectives, you're entitled to an attorney. You're not entitled to Johnny Cochran.
Right.
Get it?
Yes. Yes.
Okay. You're entitled to a warm body that has a license, that has some experience, but is not Johnny Cochran. So if it's the most important thing in your life, why are you accepting the court-appointed attorney? I use another example. Social worker comes into your house, goes in your back bedroom to your closet and finds your secret hiding place underneath the floorboards and takes $10 million out of there and walks out of the house with your money. Okay? What are you going to do? Okay? You going to go for a court-appointed attorney, or are you going to go for Johnny Cochran? Right?
I understand exactly what you're saying now. I
So
really do.
if we're going to do that for the 10 million, why don't we do it for the kid? And it's one of these things, it's the psychology sometimes of an oppressor who has or uses certain tactics, just convinces you subconsciously to not fight and use all of your resources. And I see that so many times in these types of cases, these CPS cases, and of course in criminal cases. I mean, you may be too young to remember the O.J. Simpson case,
I
but
remember.
O.J. Simpson hired the best lawyers around, the dream team, and it was a dream team, and he wins. He's found not guilty. So, you know what that taught me? That taught me that high-priced legal help can get you out of virtually any situation.
If I may, since I came home from rehab, I was homeless before. I've overcome homelessness. I have since got a job in my own place. I since got a job making $45,000 a year. Now that my mind is right and I'm back on my meds, I have really been focusing on the law, and I have filed a complaint with the Office of Children's Ombudsman. I don't know if I said that right, in Virginia. I have emailed several. Like I said, I did pay $350 for a consultation with what I call a real attorney. And I was very disappointed in what they told me was that that's what they told me. The time to fight that was 30, 60, 90 days. They were like, once we get a final order, if I wanted to hire them at that point, then they would certainly represent me. But at this time, they cannot rise above the evidence. Now, this was before I was exonerated of that charge that I spoke of. But I've also emailed almost every attorney with a good reputation in Lynchburg, just telling them my story. I just copied and pasted the email address and just send it out there. Hey, this is where I work now. This is my story. This is what I'm trying to do. If you'll just work with me, I can come up with the down payment. So hindsight is 2020. And I am realizing everything that you're saying now. And even though attorneys are telling me it might be a little late in the game, but I'm not giving up. That's why I'm here. I wish I had found you or knew about you and this whole website or Facebook group like last year. I don't know. And I don't even know how you popped up on my, I'm like, where has this man been all my life? Like, I really could have looked. I've been watching your videos and your seminars, and it's just so much information. And I'm not giving up just because,
Right.
I didn't get an attorney in the beginning.
First of all, I want you to do me a favor and go to my YouTube channel. There's more information on my YouTube channel than there are on my Facebook groups.
I've been there. I have.
Okay.
Thank you.
Make sure you like and subscribe. But this is what I wanted to tell you in all seriousness. Even though that all happened, you can still come up with a strategy and plan to get your child back. All right. So instead of going to the attorneys and saying, hey, can you go back and fix this, which they can't, moving forward, can you get my child back home in the next month or 2 months or 3 months? Okay. Because I'm not familiar with Virginia law, but in LA or California, there's a document that we could file right now to get you back into court within a few weeks. It's called a 388 petition. Okay. But anyway, so talk to lawyers. Hey, I got screwed. I don't expect you to fix it, but can you get my child back now?
Okay.
And the answer should be from an experienced CPS lawyer. Well, yeah, there's some things that I can do.
Okay.
At least try. You don't have to wait all those months. Luckily enough, your child is with the father now, and apparently you guys get along because he lets you visit.
Absolutely.
Okay, so here's the next thing I wanted to talk about. How do you get arrested for being drunk in public?
What had happened? Well, basically, I had went
Wait,
out of town.
hold on.
I really don't want to.
Yeah, right. I don't want you to talk about it. I just thought of that. But
Yeah, let's not do that.
So wait, hold on. Suffice it to say, getting arrested for drunk in public is not a good thing for your CPS case.
Absolutely not.
As a matter of fact, the way the law looks at it is, it just confirms the judge's bad decision.
Sure.
You understand?
Sure.
So, I mean, unfortunate things happen. It's behind you. Move forward with an attorney and try to get the child back now. All right. And, even though you got the case dismissed, like going back to OJ. OJ won his trial, not guilty. And then they took the same evidence, they went across the street in civil court, and he lost $40 million. Same evidence. And I just say that to say criminal court you can win because it's a higher burden of proof. Civil court, CPS court, it's a lower burden of proof. So just because, and I tell this people all the time, and they don't get it. Just because you win your criminal case, that don't mean nothing. Nothing. This is CPS court, lower standard.
And I will be the first to admit that I have not been perfect.
Whoa! Stop saying that too.
but your Facebook group says talks about trauma a lot. It talks about trauma, and I've been through a lot. But going and getting help, and then coming home and having the very thing that I went to get help for just snatched,
slapped in your face.
It was very traumatic.
Of course it is.
It was very traumatic, and I'm dealing with it. I have dealt with it the best way that I can. Yep. Yes, maybe I have struggled a little bit more with one thing than I did the other. But it's about progress, not perfection. And we say that all the time in our meetings, that I go to faithfully. It's that's what it's about. Sometimes it's 3 steps forward, 2 steps back. Hey,
no one can judge you. You do what you do, and you do it, and you do whatever you got to do to keep yourself where you need to be. That's the way it has to be. Don't worry about what anybody else says. Don't worry about, no one judges you but you, and you're a good mom and you're doing the stuff you need to do, then that's all you need to worry about, because God will work it out, or someone will. Don't you worry about anybody else. And you should be proud of yourself for getting yourself done before someone came along and, did this. It's not like they came to you because of this. This was an after thing. You took yourself as a mother and you cleaned yourself up and did the right thing. So it sucks in that juncture, but don't you put yourself down. Don't you worry about what other people say. You just worry about you and keeping you good. That way you can be solid for your kid.
That's right. You're right. Thank you.
Words of wisdom from Darren.
That's free.
Appreciate it.
You got it.
I've never been in your position. So I can't say that I know what it's like, because I don't. I did have a CPS investigator at my house, though, one time. It was kind of funny, me being a defense lawyer. But no case was ever opened, and that was a one, like 2 or 3 hour incident. But nobody's, my kids weren't taken away from me. I don't know what I would do if my kids were taken away from me. But I do have some insights legally to try to give you information. And one of the many reasons why I have co-hosts like Darren is because they've been through this. They know what it's like, and they can relate to you. I really can't relate to you because it's never happened to me. I can imagine, right? But I don't know for sure.
It kills me that they. Oh, sorry to interrupt, Mr. Davis. Sorry, go ahead.
No, but I can help you legally and with advice. And sometimes, and listen, let's be honest, I've been accused of this before. People say that I'm not sympathetic enough to understand a parent going through this. And there may be a grain of truth to that, because I'm a lawyer. I'm not a therapist, right? And if you want to figure out how to try to get your child back, I can help you with that. One of the things I'm not good at is,
sugarcoat.
Yeah, or laying in your pity party.
Right.
I'm trying to tell you what to do,
Fight.
what you need to do to try to get the child back. And I'm really good at that. Right. So people that, like me, they're like, okay, he may be an a-hole, but he's going to give me some information that I can use and think about when I go talk to my attorney or look for another attorney.
I mean, the thing that it's because, yes, you're right, Mr. Davis. I can relate to her in this situation. What kills me is what they're doing is, and you can see it, all they're doing is hanging and baiting this woman. They know that she's a recovering addict because she's told them her story. So they know it's not a matter of if, it's when. So all they're doing is they gave her next to no reasons to relieve her jeopardy. Like they gave, like if what she's saying is 100% accurate, she's fulfilled these things. Her lawyer's not really doing anything for her. They're not trying to push the envelope to get back in. They're probably waiting for a 6-month review, and then they're going to wait for a year, and then they're going to TPR. And eventually, and unfortunately, and I'm not being rude about this, you're going to probably relapse because the pressure is going to be so hard. I mean, I hope you don't. But know this, that even if you do, that's part of the recovery process. People relapse, and it's okay. But you just need just stay above it. You can and be strong with that. And know that. But just you can't be down because of your daughter. Don't let them tell you anything different. You're a good mom. You're a great mom, and you're gonna do whatever you have to do. And I know that you will. But don't let them give you the excuse to put you back into this game that they want you to fall into, because that's all they're waiting for you to do. They're waiting for you to say you couldn't handle it. You went back to using, and they're going to snatch your kid right up. And that's what they're going to try to do. So
I got to prove them wrong.
Damn right. Just stay strong and do what, but just about you. Be you first, and then you can get your kid. You're right. Be strong and just hang in there. Don't let them make you think any different.
From a perspective of non-legal perspective, I view drug addiction as a medical condition, a disease, and I think that 25 years from now, we're going to look back on what we were doing to drug addicts. We kind of criminally prosecute them, we take their kids away from them, and that's not what they need for recovery. Many cases that I've been on over the years are just like Darren said. They take your kids away from you, and that's going to prevent a large percentage of people from ever overcoming their medical condition of drug addiction. Right?
Yeah, for sure.
And it's just the wrong way to do it. And I hate to say this, but I think it has to do with money. Many years ago, I was asked to be a speaker at a convention of CPS defense lawyers in Monterey. It's a very, very famous annual seminar. Anyway, I got up there and I told them what LA County did, in these drug cases. Many attorneys from Northern California, the different counties, came up to me afterwards and said, "Well, we don't take kids from people that have drug problems." And the reason why is because we work with them, and we the social workers get to see the children every day at school to make sure that they're being taken care of. Because the law actually in California is, if you're an addict or testing dirty, they also have to prove that you're not able to take care of the kid. But in reality, it becomes, if you test dirty, you lose your kid. We don't care if you were taking good care of them or not. There's a risk. So what it turned out was LA had figured out, maybe by necessity, because there's so many cases here, had figured out how to make money off of that. When they take your kid and place them in foster care, they make more money. Lo and behold, 10 years later, 15 years later, all those Northern Californians counties that didn't take kids away for testing dirty, they start taking away kids.
Wow.
Everyone has the LA model now. And they do it in the guise of protecting children.
Well, if I may, that's where I kind of that's where my weakness comes. When I have them to take care of, when I have responsibilities to get them up, to get them to school, to take them to gymnastics, I'm not going to go to a bar. I'm not going to, what I'm saying? I have these responsibilities. There are people counting on me. They're my drive. They're my motivation.
Yeah.
They're the only thing. They're the reason why I'm doing what I'm doing. How can they take that from me and expect me? Yeah, it's set up. I'm set up to fail. And I wanted to ask you one thing. I came across something last night when I was looking. It's called SoberLink. It's a remote testing alcohol device. It's about $300 and you got to pay $200 a month. But in other words, I guess my worker, from my understanding, or the judge or my baby's father, whoever I want, could at any time, I guess, send something asking me to, I don't know if you've ever heard of it,
No, I have.
It's a daily testing device.
Right.
Is
Right.
that
I
something
have.
that I should think about doing or
Well,
offering this course?
Well,
You
you're
know,
the only one that can answer that question, to be perfectly honest.
right. And
I
you
mean,
should tell.
I want to do whatever because that's their problem. If that's what they think I'm doing, and they're not going to come breathalyze me every day, let me prove. There's no other way to show that. And if that's the problem, I'm willing to, at this point, to do whatever it takes to show them I'm not doing what y'all think I'm doing. I'm not where y'all think I am mentally or physically, or I'm not that. And if
Right.
this
Well,
device, I don't know. I
Jennifer,
just wanted to know if California had experience with it.
okay, so that's actually a very good question, and I have heard of services like that. Now, the interesting thing is, they're used in family law cases all the time.
Huh.
I have a case right now where my client, a mom, was accused of having an alcohol problem, and the father's attorney insisted that if they were going to maintain 50-50 custody, that she get on this program. And, not only can they ask for a test on demand, but she has to blow, I think, 2 or 3 times a day, right? So technology has grown so fast, the law is not keeping up with it. So there are many ways that you can test a person's sobriety 24/7. But here's the thing: they don't use that in CPS court, not because it's been disallowed. No one's brought it up. And I'm glad you brought it up because I don't think I ever made that connection in my mind. That's a
Yeah.
less restrictive alternative.
Absolutely. I mean, whatever they want. I mean, at this point, if they want, I've given them everything they want. Every time they want me to take a hair follicle, I do it. Every time but the
That's
CPS worker is not taking the initiative to give me any kind of testing. So I feel like I have to put something in place to test myself to have the evidence that I need to get my child back.
just what I don't understand is they do the hair follicle test. Now that goes back 6 months, a year, whatever it is, and
3, I believe,
they're
90 days.
they're very expensive too. On top of it, and the inaccuracies and everything that can go on with it. But nonetheless, why are they going to keep doing these to these people?
I don't know, because you
Like,
can't tell how
how
much you
many of these you got
used.
to, like they're giving them every other week. They're doing, obviously has to do with money. It clearly has to do with money. But like, are you able to defend that as an attorney? Is there a point that it's harassment, Mr. Davis?
That is an argument, but it's not a good argument inside the courtroom. And the reason is because people, have a certain way of thinking
Yeah, what
about
do you got to
things,
hide?
right? So, it's like turning an aircraft carrier around 180 degrees. It's going to take a minute. It's
Right.
just not going to be instant. And it only because of COVID were they ever allowed for you to do parenting or counseling by online, right?
Right.
Before it was like online, no, never, right? And I see online education, counseling being the thing of the future
Oh, of
because
course.
it allows people time and efficiency. But here's one thing that can be easily done online that can't be done inside your therapist's office. You can record these meetings,
Yeah.
right? That's not easy to do. Not only can you record them, you can record and share them, right?
Right.
You can record and store them for prior, for future or prior reports or future testimony. Imagine, you have sessions with your with your therapist, and you're able to play that as evidence for the judge
Mhm.
instead of just relying on the therapist's memory or the therapist's notes. But
And
technology has outpaced the law, and hopefully one day, things will catch up. But it's like anything else; it just takes time. Jennifer, go ahead.
I was just going to say, you were talking about my attorney. When I went to him and I was like, why aren't you fighting? Why aren't you, presenting this evidence? I need somebody that's going to fight for me. He was like, well, there's 2 approaches that you can take. This is what he says to me. I've learned that you can just, make DSS your best friends and be compliant and say, yes, ma'am, and smile with a smile, or then you can be combative. And it was his choice to take that nice smile compliant route. Never mind. But I just looking back now and thinking of how he talked me out of standing up for myself. I'm so disappointed in myself. But yeah, he
No, don't
actually
be.
said that
Don't,
to me, you know, that man,
Jennifer.
I need a fighter.
Jennifer, don't be disappointed, because attorneys, no matter at whatever level, are very persuasive. Some people even say manipulative. So convincing you to do a certain strategy probably is not a difficult thing. All right. Unfortunately, your attorney may have picked the wrong strategy, and that happens, right? If it worked, we wouldn't even be talking. And sometimes it does work. I'll be honest.
Well,
There
I
are
get
many different
disability
strategies.
for alcoholism. At some point, with her putting that in that order, can she do that? Can she say, okay, first of all, drugs was the initial problem. Can she, if I'm clean at this, 8 months later, say, okay, well, I'm glad you're off drugs, but we're going to take the alcohol too. If I am on paper, I get disability for being an alcoholic or for being bipolar, or whatever the case is, if that's a disability, is that covered like by the ADA, or is there, I mean, can she really tell me in a piece of paper that I can't drink legally? Can she?
As long as you're under her jurisdiction. Now, you can drink all you want. You just won't get your child back.
Right. You didn't pay the
Right.
consequences, right?
I mean, I
So
just
like
wanted
the
to know.
ADA,
But
the ADA has,
there's something that social workers and judges say all the time. Alcohol's a drug.
Right. Right.
so I know that the ADA right now has come out with that they cover opiate addicts are now considered they're covered under the American with Disability Act. Only, however, if you are a recovering non-drug using opiate addict. So if you are, you got to be clean and all that, and then they will
Oh, yeah.
represent you as far as that goes. I know that they're on that ridge with the opiate epidemic and
Oh,
everything. So
thank you for that. Okay.
yeah, so check it out. I mean, obviously read it for yourself and everything. You just,
Mhm.
but if you type in opiate ADA and on a
Sure.
Google search, it will come up for you.
Thank you.
Jennifer, before we're running out of time here, did you have any questions you wanted to ask me?
At this point, so now I have this child protective order, this hearing that has been put back on the docket. What is that, a final order? I mean, if it was going to be adjudicated, I mean, I don't
No,
understand, I guess the whole
it-
adjudicatory dropping off. I don't understand that whole thing.
okay, I
Um,
can't answer that accurately
Yeah.
because I don't know Virginia law, but it
Sure.
sounds like that they gave you the child back, or we're going to give you the child back, because the matter had been, the issue of the drugs had been resolved. But when you got that arrest for the drunken public, they're just not going to let that go and ignore it.
Well, they gave custody to the father, and I didn't think that custody could be changed like during a removal proceeding or during
Oh,
the
yeah,
protective orders. The
absolutely,
father has custody, so they weren't going to give her back.
absolutely. In California, they do.
Yeah, so they weren't going to
Unfortunately,
give her back. They told me I could go back before the
They
court.
did the same. Yeah, they did that with us. They took
Yeah.
me out and gave it to Mary.
Yeah,
so
and they told me, I could go back and ask, for, I guess, any visitation or joint custody or whatever, once I felt like I, was ready or whatnot. But no, I don't think so. I mean, at this point, you're saying it's no need to look backwards. There's no need, there's no way of going back and saying that they took her without cause when that hair follicle exonerated me. I mean, that's just,
right.
I mean, if I gone beyond the point of appeal, if I get a final protective order, if they implement a final protective order, is that appealable?
Yes.
Yeah. Okay. Is this protective order that I have now appealable? Is there anything I can do now to appeal the decisions that have been made up to this point?
That you would have to ask your lawyer in Virginia.
Okay. Okay.
In California, the answer would be yes. And if you couldn't appeal it, you could file what's called a writ. It's a discretionary appeal.
Okay.
So,
I thank you so much for your information.
Okay. But focus on going forward. Okay.
Sure.
Don't focus on the past.
Right.
Focus on going forward.
Sure.
One foot in front of the other, Miss Lady.
Now,
One foot
if
in front
you
of the
ever want to sue the social worker in federal court for civil rights violations, you might want to go back. But that's not going to help you get your child back. They'll get you
Uh,
money if they violated your rights and you can prove it and you get
sure.
past the qualified immunity. You know, a lot of big ifs there. But if that's not what you're worried about right now, just move forward with your CPS case, get your child back, and if you want to sue, talk to a lawyer after you get the child back.
Okay.
That's my advice anyway.
Sure. Sure. Well, thank you for having me.
All right, Jennifer. Well, thank you for coming on. I appreciate it.
Good luck.
There was a time I was visiting the Richmond area, several times a year. Not so much anymore, but I was very surprised. Really liked that city.
Yeah, it's
Kind of
it's beautiful here. It really is. So
All
thank
righty.
you.
Well, good luck to you. Keep in touch
Thank
with
you.
us. If you have any questions, give me a call. Number is in the bottom right-hand corner, 888-888-6582. All right?
You reading that stuff that I'm writing you?
Am I what?
Did you read those comments I wrote to you?
It's hard for me to talk and read the comments, and the comments are coming from 8 different social media sites.
Oh.
So it's hard
That's a
for me
very
to
nice
keep up.
lady. I really hope she does well for herself. I really hope
Yeah.
she does, because it's so sad to see that CPS, DHS, whoever they are, that they just set these addicts up to fail, and it's such a shameful thing that they're not only ruining a child's life by removing them from their families, but then they're ruining these people's life that are really struggling, especially someone like her that was already trying to go out and get recovery before this happened. Like it's really a shame to see that they're allowed to do such things to these people that are really trying. It's very sad. Hopefully she can hang on. And I mean, I hate these cases because especially that, if you're a substance abuser, the outcomes aren't, unfortunately, the writing's on the wall for you. Like they seem to be able to bounce around so much. So I think that's why it's so great that you talked to your guy the other day, because I saw that little spark in you that said, whoa, something different. I mean, it must be hard, right? Substance abuse for you, because that's all hypothetical.
Mhm.
Like it's a hypothetical thing. You got to fight against something that's not there or doesn't exist already,
Absolutely. Absolutely.
Yeah.
All right. By the way, I saw your comment in the private chat. And
I was
responded.
reading and listening, so I got
Okay.
you.
All
All right.
right. So thanks for joining me today, and hopefully I'll see you tomorrow at 9:30.
Yes, sir.
Grace, my producer, I know you're off tomorrow, but send me a text of the guests and everything and what we're supposed to be doing tomorrow at 9:30. Alrighty, folks. Thank you. Have a good rest of your day today.
All right, Mr. Davis. Talk to you soon.
Bye-bye.
Bye-bye.